Hi, welcome to My Court Coach. I'm Jaylyn and I'm going to be your instructor as we navigate through the form DV-115, Request to Continue Hearing. So when do you actually complete this form? You're going to do it on the day of your temporary restraining order hearing or your domestic violence restraining order hearing. You should have already received a temporary restraining order, and now you have a restraining order hearing that's coming up and you need more time. Typically, the responding party is the one who completes this. Typically, they're the ones that need more time. However, the court does allow for the moving party to continue the domestic violence restraining order at least once. However, anytime after that, you must be prepared. And this rule applies to whether you're the moving party or the restrained party, the alleged abuser. So the court will allow both parties at least once to continue the hearing, and that is it. In order for you to continue it more than that, then there has to be what they call a good cause. So a good cause could be, well, we have several witnesses and we need more time than what the court's allowing us on that particular day to have those witnesses on the witness stand, and therefore we need a new hearing date. That could be one reason. Or that there's an agreement between the parties that they want to continue the hearing so that they can exchange more information in preparation of the upcoming hearing. Or an attorney is now on the case and they just been retained the morning of or the day before. So situations like that would allow you to continue the hearing, but remember, you only have that request available to you once, and the court will actually grant it. But anything more than that is going to require some strong good cause reasons or an agreement from the other party. So if you're the person that's requesting the continuance, you're going to write your name and you're going to write whether you're the protective party or the restrained party. And then you're going to also list the address where you received mail. So this address will be used by the court and the other party to notify you in this case. If you want to keep your home address private, you can use another address like a post office box, or another person's address. If you have their permission, if you have a lawyer, give your lawyer's address and contact information. So the address, the city, state, and zip, and then your telephone, email, and fax number. Those are all optional. You do not need to provide that. And then if you do have an attorney, then you're going to write their information as well. And then information about your case, so who the other party is in this case, that you have a court date currently and what date that is scheduled on. Is there a temporary restraining order in effect? And if the answer is yes, then you're going to attach a copy of the order if you do have one, and the date that the restraining order did go into effect, so essentially the filing date of the temporary restraining order. If you don't have one or you don't know, then you could also check off those boxes. And it says if your court date is rescheduled, then the temporary restraining order will remain in effect until the end of the new court date, unless otherwise ordered by the court. So that's also very important for you to note, because the rescheduling of the restraining order doesn't mean that it's just going to expire the day that you go and ask for the continuance. It's going to remain in effect until your upcoming hearing. Now, why does your court date need to be rescheduled? You are going to say, I'm the person asking for protection and I need more time to have the restrained party personally served. So that's also a very common reason as to why you need the continuance, the rescheduling, is the other party didn't receive the paperwork and you need more time. And the court will grant that to you actually several times, not necessarily just once. And then I'm the restrained party, and this is my first request to reschedule the court date or some other reason. So like I said, an agreement could be a reason why you're rescheduling it, or somebody new is on the case, or whatever reason that you think would be sufficient as to why you need it to be rescheduled. If the court hints that you're actually trying to reschedule it to delay especially if you are the moving party and you just want the temporary restraining order to be in effect as long as possible, then the court can deny your request outright and proceed with that hearing that day. So it's very important to talk to the other party, whether they're going to be in agreement with the continuance, and if not, and if this is your first time asking for that request, then the court can in fact reschedule the court date. One of the tricks that you could actually use is if you are the moving party and the court is going to deny your request to continue the restraining order, then you could come up with the witnesses and how you want your witnesses to testify, but they better be there on the day of your actual hearing that you're making this request to continue it. Then the court is going to find or should find good cause to continue the restraining order hearing because they do believe, and rightfully so, that you have a right to a fair trial and a fair opportunity to be heard. And if that includes your witnesses, then you can ask for time to allow for those witnesses to go on the witness stand. So that's a little trick that you could use to try and continue your upcoming restraining order hearing. All right, so you can type in your name, and the lawyer's name as well will be included on there, and you file it on the day of your restraining order hearing. I hope that you found this helpful, and best of luck.